So the next subtopic is international aspects. Firstly, the impact on non-EU businesses. So non-EU established organisations will be subject to the GDPR, where they process personal data about EU data subjects in connection with offering goods or services. And in this regard, payment is not required. So the GDPR has given guidance that in identifying whether a controller or processor is offering goods or services to data subjects in the EU, the mere accessibility of a website in the EU or of an email address or other contact details is insufficient to ascertain that intention. But when you start to factor in things such as the use of a language or a currency generally used in one or more member states, and the possibility of ordering the goods or services in that other language, this may make it apparent that the controller envisages offering goods or services to data subjects in the EU. And non-EU established businesses will also be subject to the GDPR, where the processing involves the monitoring of behaviour of data subjects within the EU. So the recitals to the GDPR have said that monitoring specifically includes the tracking of individuals to create profiles, including where this is used to take decisions to analyse or predict personal preferences, behaviours and attitudes. So it follows that companies that are based outside the EU but are nonetheless processing personal data about EU residents in the context of profiling will be subject to the GDPR. International data transfers. Well, the restriction on transfers of personal data is one of the more difficult aspects of European data protection law, and this is largely because of the growth of the internet and the seamless transfer of personal data across national boundaries. As Nigel mentioned, the position under the GDPR is similar to the existing regime in respect of international transfers. So apart from transfers to jurisdictions that are officially declared by the European Commission to be adequate, both controllers and processors may only transfer personal data outside the EU if they put in place appropriate safeguards. So the GDPR continues to allow for the designation of third countries as providing adequate level of protection. But a notable change is that the Commission may also decide that specific industry sectors are adequate in terms of data protection. And although existing adequacy decisions will remain in force, the Commission is now going to be under an ongoing obligation to monitor the developments in third countries, which could affect the adequacy decisions already awarded. The GDPR will continue to allow for transfers of personal data under the model clauses adopted by the Commission, and this is the current principal means of transferring data outside the EU. But following the declaration that Safe Harbour was declared invalid, the Irish Data Protection Commissioner in May last year announced that it was going to seek clarity on the status of the model clauses, so it may be that these are under threat. The GDPR gives official recognition to the possibility of transfers based on an organisation's binding corporate rules, and also seeks to introduce other mechanisms to legitimise data transfers internationally, which include transferring on the basis of standard data protection clauses adopted by a data protection authority and that have been approved by the Commission. Transfers on the basis of an approved code of conduct. So this could be a code of conduct dealing with the transfer of personal data to third countries that has been approved by the relevant data protection authority. And thirdly, transfers pursuant to an approved certification mechanism. So this could be a data protection seal or mark approved by a certification body or by a competent data protection authority in accordance with criteria adopted by the Data Protection Authority or the European Data Protection Board. And finally, the GDPR does introduce a new derogation which allows minor transfers of personal data outside the EU in certain very limited circumstances. And the purpose of this was intended to legitimise one-off or occasional transfers of personal data. For example, where an employee goes on holiday and takes their laptop or sends an email to someone who just happens to be outside the EU. But given the stringent conditions surrounding this right, so you're obliged to notify firstly the data subject and also the relevant data protection authority of the transfer, it remains to be seen how useful this right will be.